Okay. Well, now that we've said hello to everyone, I am going to ask everyone to please mute your microphones and at a certain point turn off your video, because it'll be easier for you to see one of our favorite people, Steve Schwinn, as he presents tonight. So thank you so much, everyone, for joining us for the Virtual Civic Engagement Series, sponsored by the nonpartisan organizations of the League of Women Voters, serving the communities of Warrenville, West Chicago, Winfield, Wheaton, and Carroll Stream, and the Robert McCormick House located at Cantigny Park in Winfield. In order to improve our streaming service, it would be extremely helpful if you would now turn off your video and mute your microphones. We do encourage you to use speaker view and ask questions during the presentation by using the chat box located at the bottom of your Zoom screen during Professor Schwinn's remarks. Hopefully, time permitting, we all will be answered by the end of the program. Tonight, I am absolutely thrilled to welcome once again, Professor Steve Schwinn, Constitutional Law Professor at UIC John Marshall Law School, who is going to try and help us understand the legal challenges and if there are any possible constitutional pathways to overturn the apparent results of the election by electors, state governments, or even the Supreme Court. So Steve, thank you so much for giving us of your time once again, and I'll turn it over to you. Thank you.
Barb, thank you so much. Let me just do a quick sound check. Are we okay? Does everybody hear me?
Mm-hmm.
Okay, so wouldn't you know, right as soon as I jump on a Zoom, my little dog decides to play with her toy. So if you hear some squeaking in the background, that's what's going on. It is such a thrill and delight to be with you all. I so enjoy my time with you every summer, and I was really honored when Barb asked me back to talk about the election, and just you know, jumping out of my pants with excitement to talk to you about it this afternoon and hear what you all have to say about it. I'm really interested in your questions and your comments and thoughts about where we stand and where we go from here. I'm not sure. Well, I was about to say I'm not sure that any of us could have predicted exactly where we are, but on the other hand, we all might have predicted exactly where we are. It's really a remarkable time. And so what I thought I'd do is set out some of the things that have gone on leading up to the election, some things that are going on now, and then talk about what the future looks like, given what I think we can best predict from the Trump campaign strategy at this point. And we can maybe talk about some contingencies or predictions or ways that things might play out from here. And along the way, you know, I'll be delighted and honored to hear your questions and comments. I think maybe the best way to do this is to drop a note in chat, and Barb and I can both kind of keep an eye on that. And if you have a question, I'd love to hear from you orally and be able to see your face. Let me just start by reintroducing myself. Steve Schwinn. I teach constitutional law and human rights at the University of Illinois Chicago Law School, and have been with you the last couple of summers, or 2-3 summers, I'm not sure how many now, talking about a Supreme Court review for what? At the beautiful home in Cantigny, and this past summer on Zoom. And it just is such a thrill to see familiar faces and to see you all again. I'm really honored to be here. So Barb, thank you for inviting me. I've been talking a lot about the election to a lot of different audiences. I was just telling Barb before we came on today, I had a Zoom panel this afternoon with the UIC, the broader UIC community. We had a really good attendance and really, really good questions, but literally, as it was occurring, we were getting questions about things that President Trump was doing that we'll talk about tonight that were occurring real time, and I had to quickly Google them and see what was going on, where the question was coming from, and how I could possibly respond to it on the spot. But you know, that's the kind of world that we're living in with the 2020 election. And So what I thought we might do is kind of rewind before the election and remember what was going on before the election, which I think then helps inform some things, including some constitutional issues that we're starting to see in play now in what appears to be the Trump campaign's strategy in the next phase of challenges. And so let's start there, and we'll work through the election and work through what's going on. You'll remember leading up to the election, we saw a spate of lawsuits across the country by the Trump campaign and supporters that were challenging mail-in voting. And the rhetoric here, the public rhetoric, was reflected in the lawsuits themselves. What we were hearing from the White House is that mail-in voting increases the possibility of fraudulent voting. It allows people to forge ballots, for example, or to reprint ballots, just put them on their photocopier and sign a bunch of them and send them in to the authorities. We heard this from the president, from White House officials. We even heard it from our attorney general, from a number of sources at the federal level, and it was deeply disturbing, especially considering that so many rely on mail-in voting, which, as we know, is the same as absentee voting, to vote in elections. And in the COVID era, more and more of us were relying on mail-in voting because we didn't want to go to the polls and risk exposing ourselves to COVID. So we saw a kind of sustained challenge in the public discourse against mail-in voting, against absentee lawsuits that the Trump campaign and supporters were filing in a number of different states around the country, challenging their mail-in voting and challenging, and this became important, challenging state efforts to expand mail-in voting under state law in a way that would allow voters to vote comfortably in the era of COVID. And what was operating in the background here is that you'll recall the Trump administration and the US Post Office had actually taken some actions that determinately slowed the mail in many locations around the country. And so there was some fear among election authorities that if we're relying on mail-in voting, because the Postal Service isn't guaranteeing mail-in voting to come in on time for the election, there's some concern that those votes won't get counted. And so we saw in some states, like Pennsylvania, for example, effort to expand the time in which the state would accept mail-in votes in order to accommodate the slow postal service and make sure that mail-in votes were coming in and getting counted. Now in Pennsylvania, which was the real big case on mail-in voting, what the state Supreme Court did was to modify the state law that required mail-in votes to come in by election day. It modified it and said that we'll accept votes in Pennsylvania so long as they come in up to 3 days after election day, so long as they're postmarked by election day or they don't have a postmark at all. Now, what was interesting about this challenge is that state law kind of had that in place, this idea that you've got to have your mail-in ballots in by election day. And it was the state Supreme Court that said, well, that law really violates the state constitution and could potentially disenfranchise some voters. And so the state Supreme Court says, we're going to extend that 3 days out beyond the election. The Trump campaign didn't like that one bit, and they took that case on up to the Supreme Court. Now, the Supreme Court split evenly on the question and suggested that state authorities set aside those votes that came in up to 3 days after the election because they might be litigated later. Now, it turned out that the count in Pennsylvania didn't turn on those votes, and so it didn't matter anyway. But we did have a Supreme Court split decision that prompted state authorities to segregate those votes for potential later litigation. Now, this is significant. Here, I want to go into the weeds here for just a second because it may be significant in what we're seeing with the current round of what appears to be the Trump campaign strategy going forward. The dispute was whether the state Supreme Court had authority under the federal Constitution to extend to 3 days the time in which voters could submit their mail-in voting. The reason this was a federal constitutional question is because the Federal Elections Clause says that it's the state legislature, and here I'll use air quotes because it literally says state legislature. The state legislature has the power to direct how a state conducts its elections, unless it hasn't in this case. And so the question is, if the state legislature before the election directed that mail-in votes need to come in by election day, can the state Supreme Court reverse the state legislature and allow those votes to come in up to 3 days after election day under the state constitution? And to put a finer point on it, the dispute is between the federal constitution's meaning of state legislature. Does it literally mean just the state legislature, or does it mean something broader? Does it mean the state's lawmaking process, which would also include the governor's signature and potentially a state Supreme Court ruling that says that a legislative law is constitutional or not? Now, that was a lot of detail, but it's important as we start to look forward to the Trump strategy, what appears to be the strategy, now that its litigation strategy seems to be running out of gas. And we'll talk about that in a second. I mentioned the other thing that we saw pre-election, and that was the slowdown in the US mail. I've been doing some work on this recently because I'm finalizing on the separation of powers in the Trump administration. And as it turns out, the United States Postal Service is a kind of model of political independence within the executive branch. The way it's designed is really unusual and insulates it from the ordinary politics of the White House like no other agency within the executive branch. And that's by design. And so when the White House infects the United States Postal Service with its politics, that's really jaw-dropping, right? This is not the kind of thing that happens every day. In the era of the Trump administration, you know, we become so sort of accustomed to things that don't happen every day, actually happening every day. But I got to say, this was a real jaw-dropper when the Postmaster DeJoy started issuing orders that had a determinate effect on the delivery rate in many locations right before the election, when so many states were relying heavily on mail-in voting. And so we see this kind of two-pronged approach by the Trump administration and the Trump campaign through litigation and through administrative action to effect the election and really set up its strategy after the election. So from there, we move to what happens after the election. Now, we all know what happened on election day. And in the ordinary course of things, if what happened on election day happened in any other election, what probably would have happened is we would have seen a concession speech by Wednesday or Thursday after the Tuesday election. We obviously didn't see that, and we haven't seen it yet, and that's one of the markers of how extraordinary this cycle is. But the other marker is how heavily litigated it is. So one of the strategies that the Trump campaign has adopted after the election, the Trump campaign and a variety of supporters of the Trump campaign, is to litigate these questions. And the litigation has proceeded along, I've got to say, it's really kind of spaghetti on the wall approach, right? It's let's challenge everything and see what sticks. We're going to challenge it in state court and federal court or any tribunal that we might possibly challenge it in and just see what sticks. But I think we can generalize along two lines. What we see is some challenges to voting itself. And what I mean by that is challenges to particular methods of voting. So there are some lingering challenges to mail-in voting, rules and regulations and deviations from rules of regulations to accommodate mail-in voting, challenges to things like signature matches, to security envelope inclusion in Pennsylvania, things like that, that we've seen that have largely challenged a number of individual votes that are insufficient to turn the election in any state. And what we've seen in those cases is time after time, judges asking the Trump legal team, where's your evidence? And the Trump legal team coming back and saying, well, we don't really have any determinate evidence. What we have are rumors and innuendo, and the judges then kicking the cases out of court. This has occurred so often that some high-powered firms that had been working with the Trump campaign are now dropping out of these lawsuits. Their lawyers are asking to be withdrawn from the lawsuits because they're recognizing how weak these claims are. And we're now seeing Rudy Giuliani and a kind of B string of lawyers step in and try to take over and litigate these suits. And they're, again, today we've seen a number of cases come down sort of equally unsuccessful at lodging claims. The fundamental problem here is a lack of evidence, a lack of proof. And so challenging individual ballots is kind of one litigation strategy that the Trump team has been pursuing. And that's pretty close to have run its course at this point. The other litigation strategy that the Trump team has been pursuing is to challenge the method of counting and the method of tabulating votes. And so the Trump team has now famously challenged the Dominion systems that you've all read about in actually counting and tabulating votes, and lodged some pretty outrageous and spurious claims against the Dominion company itself, but against these voting machines as well. And then it's also lodged some challenges that we all know, have heard and read about the Trump team being locked out of observer status when voting authorities are counting the votes. Well, those claims are turning out to lack evidence as well. With regard to the Dominion voting machines, there's just no evidence that there are any problems with these machines that aren't human error. Rudy Giuliani has now famously alleged that there's this kind of nationwide conspiracy in locations that share a single characteristic. They're predominantly Black. And a number of folks have said, well, this is, a troubling claim for a number of different reasons, but not least of which it simply lacks any evidence. So on the Dominion voting side, we haven't seen a whole lot of rulings on this, but I think we're going to start to see some rulings flatly rejecting that type of claim to the extent that they even get traction in the courts. With regard to claims like locking Trump observers out of the counting locations, well, those have been dismissed as well, with one important exception. They've been dismissed because the Trump campaign, again, has been unable to bring evidence forward to show that members of the Republican Party, and indeed in some instances of the Trump campaign itself, have actually been in the counting locations and have observed the counts right alongside Democratic observers, just as state law allows. And moreover, we've all seen video footage at this point of live cams in the voting locations, right, that are broadcast on the internet. So not only can the Trump team see this, but we can all see it. And so it's a little hard to argue that that Trump campaign representatives have been locked out of observing the vote counts, when in truth they haven't. To the extent they have, it's because other Republicans have been in pursuant to state law. And to the extent that this is a problem at all, it really isn't, because we've all been able to watch these counts. And that's kind of the way these suits have been falling out. I did mention that there was one important exception, and this was out of Pennsylvania, where a judge ruled that the Trump team was allowed to have observers closer than 20 feet to the counting, that they could come as close as 6 feet to the counting so that they could get a clearer view of what the counters were actually doing. It turned out not to matter much, because it just, observing the vote really never turns the vote. And so this was an attack that never was going to turn the election, but nevertheless an attack on the integrity of the polls. Now, out of those two litigation strategies that we're starting to see sort of, as I said, kind of run out of steam, as they're running out of steam, we're also recognizing that these strategies are setting up the next strategy that the Trump administration seems to be adopting, and that is to publicly undermine the legitimacy of the election, so much so that the Trump team can persuade Republican state lawmakers in certain states, in particular Pennsylvania, Michigan, and Wisconsin, to certify their own slates of electors in favor of President Trump, as opposed to the popular vote in the state. Now, this can play out in a lot of different ways, but the strategy is becoming clear. The one thing that came up in my Zoom call earlier today, for example, was that President Trump had actually called individual Republican state lawmakers in Michigan and invited them to the White House so that he could lobby them to do exactly this. It's actually fairly jaw-dropping that I just said that, but that's where we are in this election. This seems to be the next stage of the strategy, and if this happens, we're going to be in a place where we have been once in our history, and it didn't work out so well. So, what happens if a state legislature certifies a slate of electors contrary to the popular vote in the state? Well, to understand the significance of the question, let me give you a little bit of background on this. Every state in the union has a law on the books well before the 2020 election that says that the state's electors will be certified to the popular vote winner in the state. The only two exceptions to that are Maine and Nebraska. Maine and Nebraska apportion their electoral votes by congressional district, and there are two electoral votes that correspond to their Senate seats by the popular vote in the state. But as a general matter, all states do have this law on the books that say how their electors are going to be apportioned, and they're apportioned according to the will of the voters within the state. Now, here's where that earlier case came in, that case about Pennsylvania and the Pennsylvania Supreme Court that went all the way to the United States Supreme Court. The US Constitution provides that state legislatures, in addition to directing the way the state conducts its elections, that state legislatures also get to direct the way the state allocates its electoral college votes. Now, all state legislatures have done this, as I said, by enacting a law that's been on the books well before the 2020 election. And so you'd think, okay, well, we're done with that, right? Well, not so fast. What the Trump team seems to be arguing here is that we can get Republican state legislators to certify a slate of electors because, and this is where that Pennsylvania case comes in, because under the US Constitution, it's the state legislature and the state legislature alone that gets to certify the slate of electors for the state. And so if the state legislature wants to go back on its own law that certifies the electors to the popular vote in the state, well, the state legislature can do that because the state legislature has plenary authority over the direction of the electoral vote. Now, that's a significant question. And what the Supreme Court seems to have signaled in that earlier case dealing with the Pennsylvania ballots was that the court might be split on that question. Now, when the court split on that question, it didn't include Justice Amy Coney Barrett. We have no idea how Justice Amy Coney Barrett would rule on this, or in truth, how any other justice would. But there's good evidence at this point that if that kind of case got to the Supreme Court, it would present a significant question for the court. It's not at all a no-brainer. And so the Trump team seems to be playing on this and that very narrow reading and understanding of state legislature under the US Constitution, the electors' laws, that grants the state legislature the authority to direct how state electors are going to be named. If that happens, we've got a potential for a state, say Michigan, for example, to certify two competing slates of electors to Congress. Now, there are a series of deadlines that states have to meet in certifying their electors to Congress. So all this is spelled out in a Byzantine act called the Electoral Count Act. It's a federal law that was enacted that specifies certain deadlines by which states have to certify their electors, by which time Congress receives the electors from the states, and how Congress then votes on the electors from the states. But what happens if you have two competing slates of electors is that the Electoral Count Act provides that if the governor has certified a slate of electors December 8th, that's called a safe harbor date, then the governor's certification prevails. If you're in a case like, if you're in a state like Michigan, you've got a Democratic governor who's going to certify to Biden according to the popular vote of the state, a Republican state legislature that could potentially certify to Trump under the electors clause, and that would be the two competing slates of electors. In that instance, if the governor had certified before December 8th, under the Electoral Count Act, the governor's certification would prevail. If the slates came in after December 8th, we're in much less certain territory. At that point, the House and the Senate would actually get to vote separately as to which slate to accept. And given the composition of the House and the Senate, well, I say this cautiously because we still won't know that composition of the Senate for some time. But if the composition of the House and the Senate in the next Congress stays the same, where the Democrats control the House and the Republicans control the Senate, what would happen in that instance is that they would disagree as to which slate of electors to accept. And again, a good reading of the Electoral Count Act would throw the election then to the slate of electors that the governor had certified, which again, in the case of Michigan, would be for Biden. But all this, all the deadlines, everything under the Electoral Count Act is subject to potential constitutional challenge if we did have two competing states of electors. And that again goes all the way back to that Pennsylvania Supreme Court case and this idea of what constitutes or what counts as the legislature of a state in directing who gets the slate of the state electors. If we find ourselves in that territory, we really are in uncharted ground, quite literally. We've never had a situation where completing slates of electors have been presented to Congress and then Congress has voted on them in a way that determined the outcome of the election. Now, it turns out that in 1876, we did have 3 states that submitted competing slates of electors to Congress. Congress didn't vote on them, however. Instead, Congress worked out a compromise between the parties and installed a Republican president in exchange for dropping Reconstruction in the South. Now, that was devastating to the Reconstruction effort in the post-Civil War era and set the cause of equality and equal rights back tremendously. But it did resolve the dispute without throwing it to Congress. Could we see a similar kind of compromise today? It's hard to see how that would play out today, but maybe. I wouldn't rule anything out in today's politics. But I guess, you know, it's kind of where we stand today. And you know, a lot of uncertainty, a lot of weird things going on, and new things coming at us literally by the hour. A couple of other things have happened in ordinary politics that I think are important to keep our eye on as well. We saw in Michigan this week a really interesting and, in my view, quite disturbing move by the Board of Canvassers for Wayne County, which includes Detroit, but also includes some of the Detroit suburbs. The Board of Canvassers is a 4-person board that is charged with certifying the Wayne County election results to the Secretary of State in Michigan. It's comprised of 2 Democrats and 2 Republicans in a way to keep it politically independent. Well, the 2 Republicans came out and they said that they were going to vote against certifying the results not from all of Wayne County, but from Detroit alone. Now, what's different about Detroit and the rest of Wayne County is Detroit is predominantly Black. The suburbs are predominantly white. And so there were, racial suggestions at what they were doing as well, declining to certify the vote in Detroit, even though they said they would certify the vote in the rest of Wayne County. That went on for about 3 hours before they faced just fierce backlash. People were literally incredulous about this. And so the two Republicans then, late Tuesday, reversed course and said, okay, we will certify. Well, it turns out that President Trump contacted at least one of them Tuesday night and lobbied them to change their vote. And then they came back and said, we want to change our vote. This kind of White House interference with not even a state legislature, but a local election board really is jaw-dropping. And that it would actually persuade members of the board to do one thing or another is pretty extraordinary. But again, just a sign of the times we're living in. Similarly, we've seen, and I mentioned a second ago, just this afternoon, we saw that President Trump is now calling Republican state lawmakers in Michigan and personally lobbying them to certify a slate of electors that would favor Trump, contrary to the will of the Michigan voters, who would certify for Biden. Now, both of these efforts, contacting the board and contacting the state legislators, we got to understand these in the larger context of a kind of constant drumbeat of attack on the legitimacy of the election, not only in Michigan, but in Wisconsin and Pennsylvania and Georgia and Arizona and Nevada, right across the country in locations where Trump lost the election. What the Trump team seems to be doing is trying to undermine the election to such a degree in the public discourse that they can persuade Republican lawmakers in key states to certify their own slates of electors as against the will of the people who have certified a slate of electors in favor of Biden. A couple of other things going on that I think we need to keep our eye on as well that seem to be disturbing. President Trump has outright fired Pentagon leadership and fired the official at the Department of Homeland Security in the CISA division that's responsible for cybersecurity in our country. You'll remember that Chris Krebs came out and said that this was the cleanest, most secure election that we've run in our country's history. Now, I don't know if that's true or not, but the DHS official, Chris Krebs, said it and was promptly fired by President Trump. This is consistent with a pattern that we've seen in the Trump administration. It's hard to know what to make of it, if there's any significance beyond these firings other than simple reprisal. But I do think they're worth keeping an eye on. And then another thing worth keeping our eye on is a kind of bigger picture, longer picture thing that we've seen from the Trump administration going on for a couple of years now, working up to the 2020 census. The president has determined, and long ago determined, that he wanted a census count that would not include unauthorized non-citizens in the census count. We sometimes call illegal aliens. President Trump's theory here is that states and locations that where unauthorized non-citizens reside shouldn't receive the additional representation that they do under census apportionment in the House of Representatives. They shouldn't receive that representation in their state legislatures, and they shouldn't receive all that federal money that's tied to census figures when Congress doles out federal money for a broad variety of federal programs. And so the Trump administration has been on a kind of multi-stage effort to get unauthorized non-citizens removed from the census numbers for the apportionment base that the White House will certify to Congress later this year to determine the apportionment of seats in the U.S. House of Representatives, also apportion seats potentially in state legislative districts and in federal funding. There's a case now before the Supreme Court. It's going to be heard in a week or so, and on this very issue. The other thing that we've seen the Trump administration do this past year is at first delay census deadlines because of issues collecting data because of COVID, but then retract those delays and re-implement the initial deadlines in a way that put the Census Bureau in a real spot, because by that point the Census Bureau was really had to scramble to get the numbers together. A number of folks saw those moves as trying to politicize the census count. What the Trump administration seems to be doing here is just that, trying to politicize the census count, which is something that doesn't affect this election cycle, but could affect apportionment, redistricting at the federal level and at state levels, distribution of federal money, and it could affect these things for 10 years or even more after the next census, because some of these effects are self-reinforcing and will have some inertia that kind of carries them beyond the next census in 10 years. So this is a worrying trend as well. The census, by the way, has always counted throughout our country's history, has always counted non-citizens as part of the count, non-citizens who reside in the United States regularly. And so to not do this would be a real break from tradition. But just yet another thing that we're trying to keep our eyes on in terms of what the administration is doing and what the campaign is doing with regard to the right to vote now and in the future. So I've kind of been droning on and on for an awful long time. And I think what I would love to hear is what you all want to talk about.
Well, we do have a couple of questions in the chat. One question from Elise is, wasn't there a recent SCOTUS decision regarding rogue electors? What about Chiafalo versus Washington?
Yeah, that's exactly right. It's a fantastic question. This was with regard to the so-called faithless electors, where these are electors who pledge themselves to vote one way in the Electoral College, but then actually vote another way in the Electoral College. And the way this works mechanically is state legislatures will put together these slates of electors. So going into the election, there's a slate of electors for Biden and a slate of electors for Trump. The popular vote in a state then will direct which slate of electors the Secretary of State and the governor certify onto Congress as part of the Electoral College. Now, those electors are not just sort of anonymous votes. They're actual people who actually sit down this year on December 14th and cast an actual vote in favor of an actual president and an actual vice president. If an elector has been designated for Biden and therefore has pledged to vote for Biden, but turns around and votes for Trump, we call that a faithless elector. The question before the Supreme Court was, can states require electors to pledge for a particular candidate, number one. Number two, if an elector is unfaithful to their pledge, can a state penalize or punish the elector by imposing a fine, for example? And the Supreme Court said yes to both questions. States can require electors to pledge to be faithful to a particular candidate, and states can punish or fine an elector for being unfaithful. What the court didn't say, however, is how an unfaithful vote would count in the Electoral College. To understand that question, we got to understand how the count works when it gets to Congress. When a state certifies its slate of electors to Congress, Congress convenes, the new Congress will convene on January 3rd, but Congress will actually sit to open and count the electoral votes on January 6th. On January 6th, Congress will convene in a joint session to open the votes, presided by the Vice President, in this case, Vice President Pence. Importantly, this will be the new Congress, because remember, the new Congress sits on January 3rd. When the new Congress sits and Vice President Pence starts opening up the electoral votes and counting them, it'll become immediately apparent if there's a faithless elector. At that point, what I would expect is one member of the Senate and one member of the House, or likely more than one member of each body, to raise what's called an objection to a particular elector's vote. Now, if there's an objection to the elector's vote, then the Houses move and they consider the objection separately, and they vote separately as to how to resolve that objection to the vote. Now, in this election, that probably won't matter. We would have to see a number of faithless electors, given the numbers that we're seeing coming out of the states. We would have to see a number of faithless electors and a number of successful objections in order to overturn the results of the, well, I say overturn the results, in order for a faithless elector's vote to be counted for the other candidate. I think that's highly unlikely, although, you know, again, these days, I don't count really anything as highly unlikely. Nothing would surprise me these days. That was a really good question.
Well, as a kind of a follow-up, Rosemary was asking regarding the Electoral Counting Act, if it comes to a vote in the House and the Senate on which slate to accept, does each person get a vote, or is one vote per delegation, as it is when the election goes to the House when there is no majority winner?
Yeah, that's a fantastic question too. And wow, are we in the weeds? This is great, great stuff. So I'm going to say right out of the gate, these are questions, these are very good questions. And while the law seems to give us some answers, we really are in uncharted territory because we literally have never been here before. We know that if nobody gets a majority in the Electoral College, that then the vote goes to the House of Representatives, and at that point the House votes by state. If instead there are competing slates of electors, or an objection, a challenge to an elector or a slate of electors by a member of the Senate and a member of the House, then when the Senate and the House separate to move into their separate votes, they actually vote by individuals. They vote by individuals and use their ordinary procedure to resolve that dispute. Now, that's what the Electoral Count Act says. But again, the Electoral Count Act is famously confusing. Nobody really understands it. And it very well could be ruled unconstitutional, at least in part for reasons that we already talked about with regard to how it defines the legislature, for example. And so what all that means is it's a really good question. I think we know the answer, and I think it's exactly what I said. But in truth, if this were ever to happen, I would expect a question like that to be litigated, and the courts might give us a different answer.
Could it be possible that the inauguration couldn't go on time with all the possible litigation and legal maneuverings that could be anticipated?
This is the total, crazy nightmare scenario. And I noticed, Liz, you posted this question to everybody, so I'll feel free to use your name, but can you sleep at night? This is literally my nightmare scenario, and no, I cannot sleep at night. So under the Constitution, the president's term ends on January 20th. So the president is out of office on January 20th, whether there's a new president or not. If nobody's been certified, and that neither the president nor the vice president has been certified in that situation. And remember, under the 12th Amendment, under our Constitution, this isn't the way we actually vote today, but the Electoral College votes separately for the president and the vice president. And it turns out that the House and the Senate would vote respectively for the president and the vice president if there were disputes about who won the presidency or the vice presidency. So if we got to a situation where the House was unable to resolve the presidency, and the Senate was unable to resolve the vice presidency, and the current president and vice president's terms expired on January 20th, then we have to look to the Line of Succession Act, which would put House Speaker Nancy Pelosi in the presidency. Now, that I think is, if anything, is a strong incentive for Republicans to get this resolved before January 20th. It's that, right? Nancy Pelosi, for as much as she is adored by Democrats, is reviled by Republicans, and they want to avoid that at all costs.
Could be our first female president.
Yeah, could you imagine? Oh my goodness. And then Barb, I think we'd have to say, well, President Trump is responsible for our first female president.
Yeah. Imagine the machinations over that.
No, I'm definitely not sleeping tonight.
So if I just wanted to summarize all this, the thing we really need to be watching for in the next few weeks is the certification of the vote by the states, that's important, that it's done by December 8th.
Yeah.
Because then a lot of the legal contentions are gone and over, right?
That's a perfect summary of what the Electoral Count Act envisions. So the idea is that if a state certifies its electoral slate before the 8th, which is that safe harbor period, then the state's certification is presumptively valid. And it would require some, I would say, truly extraordinary, right? I don't know, so extraordinary squared maybe, action in Congress then to undo that certification. And moreover, if the governor were to certify before the 8th, which is, again, the process that the Electoral Count Act envisions, then any competing slate of electors that came in before the 8th or after, the presumption would be in favor of the governor's certification. You know, and again, that would require truly extraordinary things to happen in Congress to undo that. Having said all that, that's what the Electoral Count Act envisions. And, you know, as I had suggested, there are serious constitutional questions about the Electoral Count Act. And just to drill down on those questions, suppose between now and the 8th that both Governor Whitmer, a Democrat in Michigan, certified an electoral slate to Biden, and the Republican state legislature certified a slate to Trump. And they both sent those on to Congress. We would certainly see lawsuits in December before Congress had a chance to open the certifications. And I think at that point, the question for the court would be, under the electors clause in the federal Constitution, is it the state legislature and the state legislature alone who gets to certify the results, who gets to certify the slate of electors, in which case the Republican legislature would win? Or is it the broader reading of the legislature's authority to mean the state's lawmaking authority, right? In which case that would lean in favor of the governor's slate. You know, again, I don't know how the Supreme Court would rule on that, but we've got really strong signals from some of the justices that we would read that in favor of the state legislature. So under federal constitutional law, whatever happens in the states, even though they're largely responsible for their own elections, there's an off chance that we could see a federal constitutional challenge if that were to occur. Now, having said that, one of the things that I don't actually hear a lot of people talk about, and I'm not sure I understand why, but I think I know why, and I'll explain in a second. You know, every state has, by law, said going into the election that the winner of the popular vote gets to determine the slate of electors. And so as individual voters, we have a right to vote, right? And under state law, we have you might call it a right to have our preferred slate of electors certified onto Congress. And if the legislature after the election were to undermine that, it seems to me a quite obvious violation of our right to vote in constitutional terms of due process and equal protection rights that we have under the 14th Amendment. Folks haven't been talking a lot about that, and I don't really know why, but I think the reason might be because that is such a weird thing to say that we literally don't have the constitutional language for it. I mean, we're totally in uncharted territory when we're talking about a state legislature certifying an election in a way that is illegal under state law, but may be authorized by the federal Constitution. Wow. I mean, that's the kind of thing only a law professor could love, and only a law professor could torture his students with, right? That it's dizzying to think about how that might turn out. And it's a little frightening.
Well, it raises the question, how we as citizens, what recourse would we have if we were citizens of Michigan and that happened? What would be our citizen recourse other than waiting till the next election and voting them all out, right?
Yeah, and I think at that point we individually and collectively would have to do some serious soul searching about what it means to comport with the rule of law in an election. I think as a practical matter, I would imagine that there'd be widespread rioting. I just can't imagine otherwise. Although, you know, if the election goes Biden's way as expected, there might be widespread rioting the other way. Tough questions.
Several questions have been raised by Joanne and others about maybe it's time to get rid of the Electoral College, and could you just quickly review the process of how that has to be done?
Yeah, you bet. So the Electoral College is hardwired into the Constitution, and so to undo it formally would require a constitutional amendment. Given the politics today, that really is a non-starter. Republicans, and I don't mean to sound partisan about this, but it just as a matter of fact, Republicans have been able to benefit from the Electoral College in a way that would disincentivize them from changing it. And so I just don't see that happening in today's politics. There is another kind of backdoor way that a number of states are starting to explore. And you all might be interested in looking at this if you're interested in these kinds of mechanical questions about the way our democracy works. And they really are more than mechanical. It's a really important question. Yeah, the initiative to the National Voter Initiative, that where a number of states have gotten together in a collaborative, and what they've done is they've signed on to an interstate compact that says, if we get a critical mass of states to join on to this compact, then every state in the compact will throw its electoral votes to the national popular vote winner, which would in effect then make our election a national popular vote election, not an electoral college election, even though technically it would still be an electoral college election. The trick to this is getting enough states signed on so that they actually have a majority of the electoral votes, right? I mean, that's the critical mass. Anything short of that, there's a kind of collective action problem where states are going to say, well, I don't really want to sign on to that compact because I want to retain the strength that I have in the electoral college. And by signing on to the compact, I might be ceding my strength in the electoral college to the popular vote nationwide. I'm not sure I want to do that unless everybody's going to do it. And so you've got this kind of built-in collective action problem where it's you know, just functionally going to be hard to get a critical mass of states to do that. But at least that's a theoretical possibility that folks have been kicking around now for quite some time. And who knows, we may get there at some point.
I do have to say that there's several people on the call who are working admirably and devoted to eliminating the Electoral College. So when you said that it wouldn't be possible, I could feel their vibes coming across the computer screen. Yes, we have to do it. But
I know, and Barb, I'm a hopeless optimist about everything. But I think here that maybe the realist side of me is coming out. And who knows, the politics may change, or, you know, something may change. I think the Republican Party, many people are saying in the post-Trump era, the Republican Party is going to have to do some real soul searching here. And maybe it changes in a way that changes the political dynamics to make that kind of thing possible.
well, we do have a question from Martha, who was wondering, in these states where they're contesting the election, or perhaps the electors would not vote for the popular vote winner, what would happen to the down ballot races? Would they be affected? If part of the ballot is not accepted, what would happen to the rest of the ballot?
Oh, it's a fantastic question. And the answer is no, the down ballot races wouldn't be affected. And the reason why is because when we go to vote, I remember distinctly voting this year because we took my daughter for the very first time. Oh, you got to hear the story. So we took my daughter to vote for the very first time. And my wife and I said, look, you know, we know COVID's an issue. We'd prefer to vote by mail, but it's our daughter's first time voting it, and we really want to go with her to the actual polls. And so we did. And wouldn't you know, when we pulled up to our polling place on an early voting day, who was in the parking lot but our very own congressional representative, Lauren Underwood, campaigning. And so I went up and introduced my daughter to Lauren Underwood. Just thrilling. I mean, couldn't be happier for the first day voting. And we went in and voted. Anyway, we got our ballots, and we, like you, marked our ballot for president for, you know, either Biden and Harris or Trump and Pence, and we filled in the ballot, right? What the ballot doesn't tell us is that when we're voting for the president, we're not really voting for the president. We're voting for the slate of electors that then will vote for the president. That's only true of the presidency. It's not true of down ballot races. And so if the popular vote is affected at the presidency level, it's affected because of the Electoral College, not because of the candidates themselves. Whereas down ballot races don't have that sort of intermediary, and so we don't. It simply wouldn't affect them. But that's a really good question, and it goes to, I mean, there are so many fictions in the way that we vote, right? Given the reality of the Electoral College and the fact that we're voting for a actual president, there's a disconnect there.
It's hard to compute.
Yeah.
Rosemary asked a question. Previously, you mentioned the 14th Amendment with the equal protection under the law. Can the part of in Section 2 forbidding interference with the right to vote for electors be used as any possible argument? She goes on to say, but when the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the legislature thereof is denied to any of the male inhabitants of such states, the male part, of such state being 21 years of age, and citizens of the United States are in any way abridged, except for the participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. And so I read that. I'm not sure what it says, but I rely on you to tell me what it said.
Yeah, this is, wow. Rosemary, you reading your Constitution very carefully, and I'm thrilled about that. You know, we don't often talk about Section 2 of the 14th Amendment. Usually we talk about Section 1, which deals with equal protection, due process, privileges and immunities, citizenship, and Section 5, where Congress has authority to enact federal legislation to protect civil rights against states. But Section 2 does contain this provision. It's true, and it's a rather extraordinary remedy for an interference with the choice of electors for president and vice president. It means what it says is the interference with the choice of president or vice president then will have an effect on voter representation in the future. That is extraordinary, right? When we think about today, it makes a lot more sense in 1868 when Congress enacted the 14th Amendment as part of its Reconstruction efforts after the Civil War to re-enfranchise or to enfranchise Black voters and former slaves. And what it says is if a state doesn't do that at the electoral level for president and vice president, the state is going to be punished in terms of its voter representation. Yeah, I mean, in theory, something like that could be activated. I think, and Rosemary, correct me if I'm going in a wrong direction when I say this, but the other thing that I've been hearing some murmurings about is the idea of actually criminally prosecuting individuals for interfering with the electoral vote. And in particular, individuals in the Trump campaign, even Trump campaign attorneys, and potentially supporters. I'm going to mention Senator Lindsey Graham, who called the Secretary of State in Georgia, you might have seen this week, to ask the Secretary to be sure to take a very careful look at votes, right? And that's pretty loaded. Whether somebody could be prosecuted criminally for interfering with the right to vote by seeking to work around the popular will of the voters of a state. It's going to be a hard thing to do. And the reason why is because the defense to that, I would imagine is, well, look, we think there's widespread voter fraud, right? Even if there's quite obviously not widespread voter fraud, that could, I don't know to what degree that kind of defense would work. There is another thing going on here that isn't so legal as it is kind of political and traditional. We in our country have a tradition of not criminally prosecuting political enemies for political acts, as egregious as those acts might be. And, you know, I don't think we've heard definitively from Biden on this about what a Biden team would do with anything that we've seen coming out of the Trump campaign or any efforts by supporters in the election. But for a Biden administration to pursue charges against Trump campaign officials or supporters would really be an unusual thing in our constitutional tradition. And so for that practical matter, you know, what we tend to say as kind of we the people is, look, the voters have spoken. The voters' rebuke of President Trump is the punishment that we've meted out, and there won't be anything else. At least that's the history and tradition in our country.
Well, we do have one.
I'm thrilled that you raised that. That's great. That is really good close reading.
Well, I'm sure we should give an alert to your students tomorrow that they might be discussing that very issue. Huh?
Yeah, exactly, right.
Well, one question that I've had is that one of the reasons I've heard or read that President Trump is fighting so hard to stay in office is that he fears criminal charges against him should he leave office. And the question's been raised, can he pardon himself from future acts?
Yeah, it's a fantastic question. I'm hesitating because I don't know. That's what I do when I don't know. Or I ask my students, well, what do you think? There are arguments on both sides of this. So some would say that the president can pardon him or herself because the president sits atop of the Article 2 branch, which is in charge of executing the law. The president is it turns out, the only constitutional officer in our system that itself is the branch, right? And so by this reckoning, the president, as in charge of executing the law, not only cannot be prosecuted under federal law, but can also pardon him or herself under federal law. And so there's that side of the argument. The other side of the argument is you can't pardon yourself, that's self-dealing, and moreover, nobody in our system is above the law. And so the president is going to be subject to the law like anybody else. If the president wants a pardon, it's got to be by a different person, because for the president to pardon him or herself is simply self-dealing. He's too self-interested to be able to do that. We don't have a firm answer to that question. And we've never had to ask the question in our nation's history, thank goodness. Instead, what the tradition has been is the subsequent president has pardoned the preceding president when they've deemed that a good idea. So for example, Ford pardoned Nixon for any crimes that Nixon might have committed. And that's what we would expect. Now, there is a theory out there that President Trump could resign his office before January 20th, even if for a wee bit period, right? And Vice President Pence could then step in and as president, pardon Trump and any other Trump officials that might have been engaged in any of this monkey business. Again, I don't count anything out these days, but I would say that seems pretty unlikely. Now, can Trump be prosecuted at the state level, I think is a harder question. Well, it turns out it's not a harder question. The answer is Trump can be prosecuted at the state level after he's out of office. Even while he is in office, he can probably be prosecuted at the state level. There are pending charges against, or potentially pending charges against Trump for campaign finance violations and other financial violations in the Southern District of New York, in New York, in New York City and New York State. And I expect that those will probably go forward after January 20th, after Trump is out of office. Nothing anybody can do at the federal level can immunize him from those charges. So those will go forward if there's evidence against him or his corporations.
Well, Steve, I can't thank you enough for being with us tonight. I don't see any other questions, and I think our heads are all swimming. We'll all be calling each other at 2 a.m. because now we can see. We hope to see you again soon. But I'm going to have Judy make some closing remarks. Thank you so much.
Barb, thank you, and thank everybody. It really was a treat and honor to spend some time with you. I so appreciate it. I love your questions, and I always love to see you.
Oh, thank you. Judy?
Thanks, Barb. Thank you, Professor Steve Schwinn, for making us smarter once again. We always love having you speak. Please remember this program was recorded and will be posted on the Wheaton League of Women Voters website. We won't have a program in December, but please join us in January on the 21st at 7 p.m. Mark Ailes, Citizens Climate Lobby, will be talking about the environment. So we hope we'll see you then, and enjoy your holidays. Thank you.
Bye-bye.